Good afternoon. Welcome to the Appellate Division First Department. Oral arguments. I'm going to call the calendar at this point in time. Please, just request the time that you actually need for your argument. Please keep in mind that we have poured over your briefs. We are well aware of your arguments. People versus Lawrence Ferdinand.
Yes, Your Honor. 5 minutes and 2 for rebuttal.
Yeah. 4 and 1 and 4. Morillo versus 623-631 West. Submitted. Quinatoa versus Hewlett Associates. Yes, 6 and 2 and 6. People v. Daheem Sally. 4, 2 and 4. 160 East 84th versus New York State Division of Housing. Submitted. Erie County versus NN Inc. Oh, I'm sorry. I apologize. Amicus. Oh, well, I will do Erie County and I'll come back to it. Erie County versus NN Inc. And the gentleman who stood up with you? So you should have spoken as opposed to her, but, oh, okay. So she is from where? Okay, so that's granted. So that is 6 and 2 and 6. Now, Amicus Associates versus New York City Loft Board.
7 minutes and 3 for rebuttal.
5 and 2, 4 and 4. Bernardez versus 70 Franklin Place.
Will the appellant 6 and 4, please?
For respondent, 7 Franklin Place, 4 minutes.
Yes.
For respondent, Franklin LLC and Centaur, 2 minutes.
4 and 2, 3 and 2. Narramore versus Mount Sinai Health and Hospital Corporation, submitted. Mahada versus E&A Ray Capital, submitted. First case for argument, People v. Lawrence Ferdinand. Whenever you're ready.
Thank you. Good afternoon, Your Honors. Sam Margolis from Paul Weiss on behalf of defendant appellant Lawrence Ferdinand. Mr. Ferdinand is a young man who made a serious mistake, one he takes responsibility for. But the trial court sentence is unduly harsh and severe and should be reduced in the interest of justice. First, Mr. Ferdinand did not and could not have knowingly, intelligently, and voluntarily waived his right to appeal.
And why is that?
Your Honor, the trial court did not adequately ensure Mr. Ferdinand understood the rights he was waiving or that his appellate rights are separate and distinct from his trial.
Was there a written waiver in this matter?
Yes, Your Honor, there was a written waiver that Mr. Ferdinand executed, but it is the trial court's responsibility to ensure on the face of the record that the defendant understands that the written waiver and the waiver of his appellate rights are separate and distinct from the trial rights being waived. And this colloquy was insufficient and conflated the two. As the Second Department has recognized,
This is the First Department?
Sorry, Your Honor.
It's okay. I know people make that mistake. But, so assuming that the waiver was inadequate or insufficient, this is a bargain for a plea, was it not?
Yes, Your Honor, but this court has the right to exercise its plenary power and reduce a sentence in the interest of justice, and
Your client received 5 and 3, is that correct?
That's correct, Your Honor.
5 years with 3 years post-release supervision. Is that correct?
Correct, Your Honor.
And what would the maximum be?
The maximum is 7 years incarceration and,
15, right?
15 years incarceration. And
Exactly. And so he bargained for 5 years, which is below the maximum. Why is that not, I'm sorry, what is wrong with that? I mean, that is what he bargained for.
Your Honor, that is what his counsel bargained for at the time. However, Mr. Ferdinand is a young man. He was only 21 years old when he committed this crime, and it was his only offense. In the 2 years that he was out between...
He fired the gun. Didn't he fire the gun? Then when he found the gun in the garbage, he fired it? Did he not?
Yes, Your Honor, he did.
That's kind of a big deal, don't you think? I mean, he's 21 at the time. I don't know. Firing a gun straight up, luckily no one gets hit.
Yeah, he did discharge it more than once, did he not?
Your Honor, the record is not clear on that, and police recovered only a single shell casing from the scene of the crime. It is a serious crime. We do not dispute that.
9mm weapon too, correct? That's not a pea shooter.
That's correct.
Okay, all right.
Your Honor, we do not contend that this is not a serious crime. It is. But it's one that Mr. Ferdinand takes responsibility for. On the day of his arrest, he explained that this was not the right way to do things. He understood that. But he had been attacked as he was leaving an apartment. He had been robbed. He was acting in self-defense. That does not excuse the crime by any means. But given his young age...
So he happened to find this gun in a garbage can?
The record is unclear on that, Your Honor.
But all the information that you're giving us in terms of his age, in terms of his being remorseful, in terms of his statements, was this information known to the sentencing judge?
Yes, Your Honor, all of this information was before the sentencing court. But regardless, the sentencing court's sentence was still excessive, and it should be reduced today because Mr. Ferdinand is just a young man who's ready to be out and with his family and contribute to his society.
You know when his sentence is up? If we were to hold his original sentence, when would he be out?
His sentence would be up. He was sentenced on March 18th,
2020.
March 12th, 2018, so he would be out in 2023.
2023, okay.
Thank you. You have time on rebuttal.
Thank you.
May it please the court, Brent Yarnell for the people. 21 years old is old enough to understand that you are not allowed to run around the streets of Manhattan firing a gun. I'd just like to spend...
Well, counsel, the waiver of the right to appeal in the transcript, we can agree that it might be deficient. Was there anything else that would supplement that?
Well, the written waiver was extremely detailed and covered all points that need to be covered by a waiver. With regard to the oral colloquy, I would direct Your Honor's attentions to the oral colloquies in People v. Sanders, Court of Appeals case, People v. Ramos, Court of Appeals case, People v. Bryant, Court of Appeals case, and also People v. Wolf, a First Department case. If you compare the language of those colloquies to the language of the colloquy here, it is crystal clear that this colloquy was totally sufficient and didn't mischaracterize the rights the defendant was waiving. With regard to the facts of the crime, there was a question about whether there were multiple shots. Here's how defendant himself described the crime in his written waiver. He says, quote, "I grab the gun and start shooting at them." So there's two facts there. One is he uses this word "start shooting," which is exactly the same words he used in his oral confession. It's exactly the same language that was used by the witness. Start shooting indicates a continuous process, indicates multiple shots. And then he says he's shooting at these men. He says he wasn't trying to hit the men, but, you know, even though he wasn't trying to hit them, he easily could have made a mistake. He's running after them. He's shooting a gun. He could have aimed lower than he thought he was. He could have shot through a window and hit somebody in their apartment. He could have tripped as he was pulling the trigger. There are so many ways this could have gone wrong. He easily could have hit someone. He easily could have killed someone. Thank God he didn't. He received 1.5 years more than the statutory minimum. That 1.5 years is necessary to send the message that when you pull out a gun, and you pull that trigger on the streets of Manhattan, you are crossing a bright red line, and there will be serious consequences. This court should affirm. Thank you.
Thank you.
Your Honors, 2 brief points on rebuttal. First, the cases cited by the People versus Sanders, People versus Bryant, and People versus Wolf, are each distinguishable as to the oral colloquy. People versus Sanders, that colloquy was conducted by a prosecutor, and the words the prosecutor used were "as a condition of this plea," which make clear that the right to appeal is a separate right. People versus Bryant, the colloquy was first a discussion of the trial rights, then a discussion of the facts and the allocution, and then the discussion of the rights to appeal, ensuring that the defendant knew it was separate and distinct. And in Wolf, the colloquy went further, asking if the defendant's attorney answered all of his questions and if the defendant needed more time to speak with his attorney. And then as a second point, started shooting might imply that multiple shots were fired, but this is not evidence that the state ever cooperated and is not in the record. Thank you, Your Honors.
Thank you. Oh, I'm sorry, you're from Paul Weiss? Yes. Thank you and your firm for your pro bono service. Thank you very much. Next matter is Quintoa versus Hewlett Associates. Whenever you're ready.
Good afternoon, Your Honors. My name is Jeffrey Metz. I'm with the firm of Adam Lightman Bailey, PC. We represent the appellant herein. I'm here this afternoon, Your Honor, seeking a modification of the order issued below to dismiss the complaint. We believe that the complaint should be dismissed because the plaintiffs listed here have suffered no concrete injury.
Counsel, this was a motion for renewal. What is the change in the law that Regina articulated about fraud, which is the issue that's relevant to our case?
Well, what Regina articulated was that there was a 4-year look-back period in the absence of any kind of indicia of fraud, which
Let me ask you, before Regina was decided, there was an exception that existed, that if there was fraud, there'd be an exception to the 4-year look-back, and you'd have the default formula.
Correct.
Isn't that exactly the same law now after Regina?
Well,
Has
that
law
may be
changed in any way as a result of the Court of Appeals decision in Regina?
No, I think you have to look at it in the context, the way the Court of Appeals looked at it, Your Honor, because the Court of Appeals noted there and specifically mentioned the big 3 cases where there really was egregious conduct on behalf of the landlord. But an increase in rent in and of
Did the
itself.
Court of Appeals, I don't think you've really answered my question. Did the Court of Appeals, you're making a motion to renew, which is a very limited, specific second bite at the apple. And you have to show there's a change in the law. How did Regina change the law with respect to fraud?
Well, because it said in the absence of fraud, you cannot go back more than 4 years.
Wasn't that the law before?
Well, that might have been the law before, but what it did, it clarified the law, Your Honor. You have a situation here, and this case in particular shows how far afield we've come from Regina, because nowadays, all you really basically have to do is just say there's a fraudulent scheme to deregulate, and all of a sudden, the 4-year rule goes out the window. Now,
And so what did you have to say before Regina? What showing did you have to make before Regina?
well, before Regina, you had 213A. That didn't change. That didn't change. And what we're talking about was what they were talking about there in the Regina case was whether the law should be retroactive, the 2019 law, or not. But again,
Counsel, you had every opportunity on the first go-round to make whatever arguments you wanted to make about whether or not a fraudulent scheme had been sufficiently alleged for purposes of a motion to dismiss. Why should we give you a second bite at the
Sure,
apple in
okay.
terms of a renewal motion to make the same exact arguments you could have made in the
Understood.
first instance when you made the motion to dismiss?
Because, again, I think this has to be viewed in the context in which it arose. The initial cases, including mine, had to do with whether a class could be certified or not. That's what the motion to dismiss was about at that juncture. It was, should it go to DHCR? Should it stay in the Supreme Court? Could it even be subject to a class action? So that was the initial. And if you look at the initial order of Justice DeAugust, that's what he's talking about. We weren't talking about what Regina has brought to the bright light. So I would suggest to you that we did not have an opportunity to raise that at that juncture, and now it's been fully briefed.
Wait, are you saying that you didn't have an opportunity in the first go-round to say that this fraud wasn't adequately alleged? What about Grimm and 10,000 other cases that were talking about it way before then?
Well, Your Honor, we did.
I just want to know, is that your argument that I couldn't have alleged that the complaint didn't adequately state?
No, we did. No, we certainly did make mention of that.
So then how does Regina change that?
Because Regina changes what the formula is for deciding how you compute rent overcharges. And that's,
No, that's the end of the case. We're talking about a pleading motion.
well, Your Honor, I'm content to discuss the pleading motion because this complaint here, Your Honor, does not mention the word, there's no cause of action for fraud. It's not alleged in there. It is, as Judge DeAugust said, it is merely alluded to.
Those are all things, though, that you could have raised in your first motion to dismiss. Why, back to the same question, why renewal? Those are all perfectly developed, and Regina didn't change any of those arguments.
Well, Your Honor, I think Regina represents a sea change in the law of how these cases are decided.
In general, but how your case, how your motion to dismiss is decided, you still haven't told us how Regina changes that.
Well, because Regina says, in the absence of indicia of fraud, you look back 4 years, and that's what our argument is. There is no indicia of fraud.
Thank you.
I'll wait. Thank you.
Good afternoon, Your Honors. Jonathan Oring, Millbank LLP, on behalf of plaintiffs' respondents Stella Quinatoa and Ana Cabrera, on behalf of the class. May it please the Court. The issue in this appeal is straightforward. At the pre-disclosure motion to dismiss stage, have plaintiffs in this case alleged or otherwise identified sufficient indicia of fraud by Hewlett that, if proven, would entitle plaintiffs to damages under the default formula? And we submit that as the court below held, and as this court's precedents clearly dictate, the answer is yes. We believe this is an easy affirmance. You have the procedural vehicle that Your Honors have mentioned. We're not the ones who made the motion to dismiss. They are. They had every opportunity to raise these
Counsel,
grounds.
do you think Regina changed that statement of the law?
Regina did not change the question of how fraud is determined and when damages are calculated under the default formula. It did not, and we argued that below, and that's clear. That Regina clarified the calculation of damages in pre-HSTPA cases, which is the appropriate formula to use without fraud, and they said the standard formula. That was the clarification of Regina. No change, they just rehashed and summarized their prior decisions on fraud. There was no change in the law of fraud. And so the question here, have we alleged or otherwise identified indicia of fraud? Clearly, yes. We have, going back decades, Hewlett removed apartments from registration before luxury decontrol was even an option. They were unlawfully removing apartments with no basis to do so. We have what is probably the closest thing to a smoking gun that you could have, particularly at the pre-disclosure stage, which is that Hewlett submitted an application for J51 benefits in 2005 in which they blatantly misrepresented that all of the units of the Trafalgar apartments were registered. That was false. It was undeniably false. They lied, misrepresented the number of units in the building. They said there were 22 units in the building, all of which are subject to the ETPA. In reality, there were over 100 units in the building, all of which should have been subject to the ETPA. I don't know how they went from 22 to, or from 100 plus to 22. It's a blatant misrepresentation. This is on a pre-disclosure record. The only reason we even have that document is because the court, in denying the initial motion to dismiss, allowed limited disclosure. They produced 50 documents. That's one of the documents they gave us. And so that pretty much slams the door shut on whether there's any question of whether we've made a sufficient showing of fraud at this stage. But beyond that, you have, after Roberts and Gersten, they didn't return the units to registration. This court has held...
Is it your position that we should be addressing the merits of the argument? Is your primary argument that this is not an appropriate renewal motion?
Well, our primary argument in the briefs was the substantive argument. We advanced both arguments, and we advanced both of them below. We argued there was no change in the law on fraud. That was clear. It was a whole section of our brief below.
So if we agree with you there's been no change in the law, we don't need to get to the merits of it. Is that correct?
Well, I mean, it depends on how the court construed. I mean, Justice de Auguste below, he said, for the sake of argument, I will accept that Regina effectuated a change of law kind of generally on, calculation of damages in rent overcharge cases. I mean, I don't think it really matters. I mean, I think either ground is sufficient. I mean, I think the merits ground is such an easy one. I mean, all that this court has to do is adhere to its prior precedents to affirm. And it's clear, and there's overwhelming indicia of fraud. This is the most you could possibly have at this stage before you've even gotten disclosure. So we have the failure to return units to registration after Roberts and Gersten. By the way, they didn't even address in their briefs or at argument the false and fraudulent J51 application they submitted to the Department of Finance. They can't address it. A couple of other things. So they kind of hang their hat on this legal argument that after Regina, the only way that you can establish fraud for purposes of a rent overcharge claim is to show that after Roberts, a landlord affirmatively removed apartments from registration. They say that's the only way, that merely failing to return units to registration is not enough. And this court has rejected that very argument 4 times. This court rejected that argument in Nolte. That case was a failure to register after Roberts' case. They rejected their argument that fraud can only be shown by deregulation in 435 Central Park West. In Montera, the failure to re-register, again, a basis for fraud. And then most recently in the Hess case, there was no removal of apartments from registration after Roberts. It was purely a failure to register after Roberts. This court held that was sufficient to establish fraud at that juncture. And so for that reason, we submit this should be an easy affirmance. Thank you, Your Honors.
My adversary alluded to it, but Justice DeAugust did grant the motion for renewal. We did not appeal that, obviously. And he said that the court accepts defendant's argument that Regina constitutes new law on the issue of precisely how to compute a tenant's rent. And that's what our motion was all about, how you compute...
Distinguish Montera, then.
Excuse me, Your Honor?
How do you distinguish Montera?
Montera, 2 prongs. Montera, there was deregulation, post-Gersten, and failure to register. There is a definite and in that opinion. We don't have that here, Judge. All we have is they harp on it, and it's true, we did not register again to...
Isn't that, would that not be an indicia of fraud? You said they harp on it, but that is relevant, is it not?
Well, Your Honor, it really, it's funny. It depends on the cases that you read. You have a case from this court, AES 534, saying no contemporaneous filings with DHCR does not constitute fraud. Your brethren across the river said that failure to register in and of itself does not constitute fraud. The Court of Appeals has said failure to register does not constitute fraud. There is a statutory remedy, not a precedential remedy. And the fact is, if you can just say that you failed to register these apartments, when we registered them, Judge, we went back to 2007, the first year of the J51, and we gave, that went back 11 years rather than the 7. And we computed our increases based on that. And when Regina came out, we recognized that, hey, you know what? The tenants have not suffered any injury here because we have refunded them monies more than they would be entitled to under the present standard. This is the whole thing. This should not come down to a game, Your Honor, of whether the default formula should apply. By just saying over and over and over again that a landlord has committed some sort of indicia of fraud when there's nothing in the complaint that says that. 3016B makes it very clear that you have to be particularized. Justice August, the best that he said was that the complaint alluded to it. Now, alluding to fraud seems to me to be the polar opposite of alleging fraud with particularity in the complaint. That's the problem here. The complaint does not allege it. There's no affidavit from the tenants alleging it. Everything is from counsel. The whole thing is counsel's argument. And understand, if you want to look at standards, sure, a plaintiff can bolster up a complaint with an affidavit, but we don't have that here. All we have is the attorney's affirmation.
Thank you, counsel.
Thank you.
People v. Dahim Sally. Yes, counsel, when are you ready?
Oh, all right, thank you. I was just going to wait for them to sit down.
Oh, I'm sorry.
That's all right. Good afternoon, Your Honors. May it please the court. Cara Labini for Appellant Dahim Sally. In this case, 2 officers alleged that they smelled marijuana emanating from the cab in which Mr. Sally rode. That testimony was fabricated, and I'll explain why. First, the driver of the cab, who sat right next to Mr. Sally, smelled nothing. We've all smelled marijuana, and it hits you like a brick wall. The fact that the cab driver did not smell anything is very good evidence that.
But doesn't that boil down to a credibility issue that the hearing court was able to weigh, and it weighed in favor of the officers at that point?
Sure, but this court also has the right and the jurisdiction to review the hearing court's determination and make an opposite finding. So that's the first reason why I believe the officer's testimony was fabricated. And second, the officers never recorded nor reported in their complaint, their memo books, nor in the interview with the ADA that they smelled marijuana prior to the arrest. That seems like one of the first things that you would mention when reviewing an arrest with an assistant district attorney, yet they did not. There was plenty of opportunity for the officers to collude in fabricating their testimony as they worked together before and after the arrest.
Well, counsel, what about whether or not this was a lawful traffic stop? I thought there was something about the vehicle not having its lights on, right? This was a green cab driver, a green cab, and did they not follow it because it did not have its lights on and it was at night?
That's correct. They followed the cab for 20 blocks, during which the headlights were not on, and were within their rights in pulling over the cab. They were not within their rights in frisking Mr. Sally.
Why not? So they pull the cab over, and then wasn't the individuals in the vehicle were moving around, doing other things in the vehicle? Is that correct?
Correct. So apart from the marijuana, the other basis for the frisk was, quote, these suspicious movements from individuals in the car. But the sum and total of the testimony as to Mr. Sally's movements came from Officer Santiago, and he testified this, quote, Mr. Sally turned around looking at me, and because of movement, I could see their shoulders dipping up and down. So first he says their shoulders, not his shoulders, meaning it could have been anyone in the cab. And second, he indicates that the shoulder dipping movements were incident to Mr. Sally turning around.
Well, I thought it was not only Mrs. Sally, but when he said they, I thought he was also referring to another defendant. Was it Kraft or something like that?
Correct. But as to Mr. Sally's frisk, it is Mr. Sally's movements that are pertinent to legalizing or making the frisk lawful, not the movements of anyone else, because the police officers needed reasonable suspicion that Mr. Sally himself was armed and dangerous in order to frisk him.
So do you take into consideration, or should we take into consideration, the activities of the defendant and the other individuals prior to their hailing the cab and getting in the cab?
Sure, I think it adds to the totality of the circumstances, but frankly, the hailing of the cab, to me, is one of the most egregious parts of the record, because alleging that people were frantically hailing a taxi and saying that that indicates that they were intending to rob it, to me, completely defies common sense. If you're frantically hailing a cab, that means you're just trying to leave the area for some reason and hail a cab, not that you're about to commit a crime and rob the cab driver. So I don't think it adds anything to the totality of the circumstances that in particular Mr. Sally was armed and dangerous.
There was a colloquy between the witness, the officer, and the court on that particular issue, right? About if the court had been frantically hailing the cab, how she would be viewed. Should we be considering that at all?
Yes, I think that the officer skirted the question in responding to the court's prompt. So the court asked why the officer would assume that the men were engaged in criminality, and I'll just finish this up if that's all right, and not just in a hurry to go to a party, the fact that they were frantically hailing this taxi. And the officer responded, and the court asked whether, if I was hailing a cab with some of my friends, would you also assume that criminality was afoot? And the officer responded that based on Mr. Sally's behavior, running back in and out of the street, looking surreptitiously, acting like he was trying to leave the area for some reason, that's why you hail a cab, and especially on an avenue like Lenox that goes north and south. We all sort of dart in and out of the street and look north and south when traffic is coming in order to see approaching taxis. And indeed, yes, we do hail taxis in order to leave the area for some reason. So I don't think that the officer really responded to the court's question about whether, about whether the impulse to stop the cab was related to race or not, because he sort of said based on Mr. Sally's behavior, meaning what Mr. Sally looked like.
Thank you. You have time on rebuttal.
Thank you, Your Honors.
Good afternoon, Your Honors, and may it please the court. Carl Dubel for the people.
So, counsel, assuming the stop was lawful and not even getting into the marijuana for the purposes of this argument, how would the officers be justified in having this defendant, Mrs. Sally, come out of the car and then frisk him?
So just based on the traffic stop alone, the officers were allowed to ask Mr. Sally to step out of the car, and I don't think the defendant contests that. The reason why they're allowed to frisk him is because they had reasonable suspicion that he was armed and dangerous. And the reason why they had that is because of the movements of all, specifically Mr. Sally, but also the other individuals in the car.
The dipping of the shoulders up and down in the back of the vehicle?
Yes, so the officers believe that they saw defendant and Kraft turn around, look at them, appear nervous, and also that they were dipping their shoulders in such a way that they're, the defendant was specifically dipping and moving his shoulders in a motion that caused his head and neck to move towards his lap. And this wasn't just a singular motion. Like, there was so much movement in the car that both officers reported that the suspension was shaking up and down and side to side. If the defendant was simply...
Didn't they also testify that the neighborhood was experiencing shootings, multiple shootings, and firearms and robberies with the weapons, and in particular, livery cabs were being targeted in the robberies? I mean, that's their focus, right? I mean, they know what's going on in the neighborhood, right?
Yes, Your Honor, that's a very important
That,
factor.
that all factors into the movements, and they're seeing everything else that's going on. I mean, it's a moving picture, right? I mean,
Yes, it adds to their suspicion because they were specifically on the lookout for people who are armed and who would be robbing livery cabs. And the defendant and the movements that he was making and the area that he was in and the type of cab that he was in supported that inference, and that increased their level of suspicion. As far as the credibility arguments, the record supports the trial court's findings that the officers were credible. Yes, the cab driver did not remember smelling marijuana, but 2 officers testified that they smelled it, and it made sense that the officers in this situation were able to remember that because that is such an important factor in their search. That was one of the main reasons why they decided to frisk the defendant. So it made sense that they remember that, whereas whether the cab smelled marijuana is kind of irrelevant to the cab driver and something that could easily
Yeah,
be.
your adversary mentioned this in their briefs, and I think she might have alluded to it a little while ago during the argument, is that none of the, there was no notation in any of the police work or in their memo book entries, their memo book concerning the smell of marijuana.
Correct, Your Honor. The officers did not notate the smell of marijuana in their memo book.
So you are arguing that this was a major basis, for them to not only stop the vehicle, but in part to stop the vehicle, but also to order the occupants out of the vehicle. So would that not be something that would be important to note in one or more of the police reports and memo book entries?
Yes, it would have been better police practice had the officers noted that in their memo book. But because it was a basis for the stop, it's something that could probably be very easily remembered. And it was noted in some of the arrest paperwork for the other defendants in the car because both defendant and another person had marijuana on them, and one of the other people in the car was charged with marijuana.
Possession, but
Correct.
not that, but that doesn't necessarily, obviate the fact that they did not note that there was a smell of marijuana, the fact that marijuana was actually found, right?
The fact that marijuana was found bolsters their credibility that they smelled it, because obviously if there was no marijuana and they say they smelled it, that clearly shows that they are potentially making something up, but that's
The
not.
the cab driver didn't smell it, right?
The cab driver did not know.
Okay, thank you.
If there are no further questions, we ask that you affirm. Thank you.
No rebuttal unless your honors have further questions.
No, thank you very much.
Thank you.
Amicus Associates versus New York City Law Board. Where's she from?
Good afternoon, Your Honors, and may it please the Court. My name is Jason Frosch of Cooker, Marino, Winiarski, and Biddens, and I represent the appellant petitioner, Amicus Associates. Amicus is the owner of a building in Lower Manhattan, 6 stories, approximately 40 units, 40,000 square feet, that's covered under the New York State loft law, and registered with the loft board in December of 2016. What's crucial in this case is the owner's request and the loft board's unlawful denial of an extension of the statutory deadlines for legalizing the building under the loft law. All of those deadlines had expired more than 3 years prior to when the owner first registered the building with the loft board. The way that the statute avoids the draconian result of imposing a deadline that's long since passed
Yeah,
prior
but when
to
did your client ask for the second extension? My record or my notes indicate that it was only a few days before the expiration date that he asked for an extension, correct or no?
That's right. So that's
Why-
actually typical because the loft board doesn't want the owner to request an extension without showing the reason why the extension is necessary. When the owner met the first extended deadline, which was to file plans with the Department of Buildings in October of 2017, they then attempted to move the process forward with the loft board in order to satisfy the second deadline, without the need for an extension. And it was only after the loft board's refusal to schedule a narrative conference, which is a necessary predicate to obtaining the permit, which is the second deadline, was it necessary for the owner to request the second extension on that basis.
Counsel, why can't they enforce the clear language of the regulation, which says there's only one extension? What's wrong with that?
So what's wrong with that, Judge, is that for the prior few decades, the loft board has routinely granted an unlimited number of extensions.
But hasn't there been a change in the regulation since that time?
That's what the city argues, but they are completely incorrect. And I show in my reply brief not only the statement of purpose, but the line item edits of the amendment to their regulations they refer to. There is absolutely no change to the language they are citing to in all of their prior decisions under appeal here, where they're claiming that this is what allows them to limit extensions to only one per owner. It's the same statute, it's the same regulations, and all the prior case line I cite to maybe 5 or 6 different cases in which the very same deadline that this owner sought a second extension of was extended 2, 3, even more times for decades in the past. There's simply no explanation the law board can provide for why they're entitled to curtail a statutory right, and this statutory right is essential to the functioning of the loft law.
Counsel,
That they're curtailing, go ahead.
there was a letter from the Loft Board dated January 18, 2018, which scheduled the narrative conference for February.
That's right.
But the permit would have had to be due by January 18th, to be issued by January 18, 2018. So would that be an indication that maybe they had intended to grant yet another extension?
Well, I don't know what their intention was at the time, and it came as a surprise that they denied the second extension on a basis of saying they can't grant more than one. All I know is, as the owner's attorney, I was attempting to get the conference scheduled in a timely manner. I just simply couldn't get anywhere with the loft board on that issue, and the first date they provided was already past the deadline for obtaining the permit in the first extension. So at that point,
Counsel, is it that they're curtailing the regulation or the interpretation of the regulation, or is it that they're just adhering to the actual words and meaning of the regulation?
well, Your Honor, the regulation says applications, plural, or extensions, plural, of code compliance deadlines will be limited to one extension per deadline in the amended code compliance timetable. That language was addressed by a respondent tenant in matter of Silverstein, which is the case I cite from 1996, and the loft board adopted the administrative law judge's rejection of that by saying the use of the word plural, applications, and extensions in that very same language warrants a denial of that argument and a upholding of the fact that owners can get an unlimited number of extensions. The statute says the loft board may, upon satisfying the standard, grant an extension of time to meet a requirement, provided the owner demonstrates good faith efforts. This same exact language has been interpreted for decades to allow an unlimited number of extensions, and it must be interpreted that way, because if it's not, no owner could stay in compliance with the loft law. And the reason for that is when an owner becomes covered, in order to deal with the fact that all the deadlines are keyed to specific calendar dates in the statute, an owner must request the extension of the already passed deadlines within 90 days of becoming covered under the law. If the loft board were only to allow one extension, that one extension would be used up immediately upon the owner beginning the legalization process, and the owner would never be able to request any other extensions during the very complex and onerous legalization
But
process.
I mean, that's, you registered in late 2016, correct?
Correct.
And as of May 17, 2017, you knew that January 18th was the drop dead date, correct?
Under the original extension, yes.
Right. And then you wait till October 2017 to even submit the application, right? And this is for fire. This is not like, you know, making sure the walls are pretty. This is to make sure that the building complies with fire codes, correct?
Of course, yes.
So doesn't it make sense to say, sure, I'll let you collect rent and have the people stay in the building, but as to fire compliance, you get one extension and no more. Doesn't that make sense? Why should you be able to continually get extension after extension after extension and be able to keep all those people in the building without a code compliant fire safety in the building?
That's the key question, and the statute addresses it by requiring that for an owner to get an extension, they must show they're making good faith efforts and that the reason for the delay was due to circumstances beyond their control. And there are many parts of the legalization process that effectively are completely outside the owner's control. They're relying on city agencies, they're relying on tenants to
Wait a
raise
minute, don't go to
objections.
the tenants thing. There's something on the record here that you guys were less than diligent when you went to the tenants.
I'm sorry, I didn't know.
The record here indicates that you were less than diligent when you were going to try and get access to two tenants' apartments.
That's right. So we tried to get access to all the units in order to draw them into the plans, and two of the tenants refused to provide access, and we had to file an access application. And the statute
And how late?
specifically,
Okay, I got it.
the statute specifically enumerates that as one of the bases for granting an extension.
Thank you. Your time on rebuttal.
Thank you, Judge.
May it please the court. Daniel Matza Brown for the respondent, New York City Loft Board.
So I just want to ask the same question in regards to this January 18, 2018 letter that scheduled the narrative conference for February, when January 18th was also the date that the permit would have had to be issued if all deadlines had been complied with. I just don't know how to reconcile those two things.
Well, Your Honor, that's one of the things that the appellants point to for the delays, but as Justice Owen recognized, there were many other delays that were solely the landlord's fault well before that, right? And again, as multiple judges noted, they waited until the last minute to make their second extension request. But we don't even need to get to the diligence or lack thereof by the landlord, because the primary basis for the board's denial and for the order below, and the primary basis upon which this court can affirm, is that the regulations don't allow multiple extension requests.
What's your response to the argument that there really was no change in the regulation?
So that argument's completely wrong, and it's raised on the first time for reply, so I'd like some time to address it here. But let's turn to page 213 of the record, which shows the regulation in its final form with the red line as compared to the previous regulations. Before 2006, there were three sorts of extensions based on how long they were. That's 213 subsection I is the short extensions, that was 90 days or less. And before 2006, that was the only one that had the cap on the number of extensions. So if it was less than 90 days, you could only get one because it was ex parte. For longer extensions, that's subsection 2 and 3, that's on 213 and 214. For longer extensions like the ones we have here, there was no cap on the number of extensions. What the board did is it totally revamped the extension system, and it said, we're not going to have like a three-tier process.
When was that done? When was the
In 2006. In 2006, they said, we're not going to distinguish between the length of extension. We're going to
So,
treat
counsel,
all the
how do you
same.
deal with your adversary's argument that even after 2006, the board wasn't taking the position that it was one and done?
That's just made up. There's nothing, he cites three cases from 1996. He cites not a single administrative decision post-2006 where multiple extensions were granted.
So it's your position that after 2006, you were consistently interpreting your own regulations?
Well,
Where it says an extension, you meant an extension?
Yes, and as Your Honor pointed out, the regulation is clear. That limitation pre-2006 only applied to 90 days or less. That's why that paragraph strikes 90 days or less. It makes the paragraph broader. It would be like saying the First Amendment is interpreted the same before and after the 14th Amendment because the text of the First Amendment didn't change. The whole regulation, striking the next two paragraphs and moving them up to the first paragraph, makes this limitation on extension numbers much broader. The language is clear, and the board followed it. Unless there are further questions, we rest on our briefs.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Elizabeth Sandercock of Goodfarb and Sandercock, and I represent the tenant respondents. The landlord's Article 78 and this subsequent appeal is really purely an attempt to collect rent from tenants without doing its legal obligation to make the building safe in terms of fire and safety and completing the legalization of the building. The loft law is very clear that in order for an owner to collect rent in a building without a residential certificate of occupancy, it has to meet...
Did tenants make it difficult for the owner here to do what he had to do? I mean, that's one of the claims, like, oh, I couldn't get in, the tenants weren't cooperating.
Your Honor, I don't think that that's the case in this building at all. The landlord claimed that 2 units out of, I believe, 10 IMD units did not provide access. In addition, the landlord didn't seek access until July 2017, even though the building had been covered in 2016. The landlord was negotiating to cover these tenants for quite a while. They could have started this work to draw up plans and prepare for the legalization as it was doing that. That is certainly quite common when buildings are being consented to coverage. The landlord chose not to do that in this case. They chose to attempt to gain access to units needed for legalization plans that summer in July 2017, and 2 units didn't provide access. That's really not a significant amount of units. That was one of, as Mr. Matza-Brown already indicated, that was one of many delays that occurred in the legalization of this building. Despite knowing that that they were not in compliance, the landlord has multiple times attempted to collect rent from the tenants in this building. They brought at least 2 non-payment cases that I'm familiar with personally against tenants after the loft board had already denied its extension application. And this is important because contrary to the landlord's claims, its inability to collect rent right now is not a penalty that's being imposed by the loft board. MDL 301 specifically states that you cannot collect rent from residential tenants if you don't have a certificate of occupancy. It's the loft law itself that gives landlords the privilege of collecting rent from tenants in buildings like these, as long as they meet their obligations.
So what is the landlord's remedy now? To start the process again, correct?
The landlord has obtained a building permit at this point. I would say that it could have worked far more diligently to obtain that building permit after it missed its deadline, and it might be further along in the process. The landlord's remedy is to complete the legalization work, which it has really only just begun in earnest, to be honest with you. The loft law's legislative purpose is to legalize these buildings so that they are safe for residential tenants to live in. It does not serve the loft law's purpose to allow landlords to obtain multiple extensions of the legalization deadlines, because this case illustrates that if they're given the opportunity to do that, they will not use it to actually legalize the buildings. They will use it to collect rent from these tenants while they remain in buildings that are not being made safe in terms of fire and safety regulations as required by the law.
Thank you.
Thank you, Your Honor.
To address what the city pointed to, there is nothing in the regulations or the statute that imposes any limitation on the number of extensions that may be granted to date, even if the argument were true, which it is not, that the language in 2006 that's relevant here was changed.
What he argues, we can look at it very quickly. We can see if 2006 was a sort of, change.
Yes.
It is what it is, right? I mean, you taking a position there was no change. He's taking a position 2006 there was a change. We'll see it for ourselves.
Right. Yeah, the statement of purpose and the language is right there. I'll also.
I hope for your sake it's accurate.
But let me just ask you, do you have any instances, or can you cite to any instances after 2006 that the city granted more than one extension on that first make this up to fire code milestone?
No, Judge, and the reason why is because the loft law had only been put into effect in 1982, and until 2010, there were almost no volume of buildings that requested an extension, since their time for requesting extensions would have been decades old. So yes, from 2006 until 2010, when the law was renewed by the legislature, there would probably have been barely any, if any at all, extension applications requested. The first one that I'm aware of deciding this issue was well after 2010, when the entire members of the loft board staff were different and were not.
And was a second extension granted?
I'm not aware of any, but
Okay.
the point here is that the language that was
No,
relied on
you made
in
an argument
2006
that this has always been the case, and you're the first person ever, your client's the first one ever, that this didn't happen
Yes,
to.
I think this is the first case where this has been preserved for appeal.
Well, that's
and
a
I'll-
little different.
Right.
You started out your argument saying that that extensions have always been granted, and that this is the first time, almost in the history, that an extension was not granted.
I'm not
But-
making that, I'm not making the argument that there's been a post-2006 case. I'm making the argument that the change to the regulations in 2006 didn't alter the language that was relied upon by the law board in the previous 2 decades on which they based their grant of multiple extensions. That's a straw man from the city's attorney.
Thank you.
Thank you, John.
Erie County versus NN Inc. You may proceed.
Good afternoon, Your Honor, and may it please the Court. Karen Porter of Simpson Thatcher and Bartlett on behalf of the appellants. The appellants are defendants in a 1933 Securities Act case in connection with a September 2018 secondary public offering. Your Honor, what we are asking you to do today is to reverse the lower court's decision and to dismiss plaintiff's amended complaint in its entirety. As outlined in the papers before the court, there are a number of independent reasons to do that today. Just one of those is sufficient for this court to reverse the lower court's decision. Each of those reasons is consistent with the black-letter law of this court and sound public policy. I'll preview those arguments before delving into them each in detail. First, the lower court improperly relied on allegations that are stated nowhere in the amended complaint. If you read the amended complaint and you read the lower court's decision, respectfully, there is a disconnect.
Example.
The facts that the court relied on in declining the motion to dismiss don't appear in the amended complaint. Specifically, I'm going to quote the section of the complaint that the court found to be dispositive. The lower court found, and I'm quoting now, that the amended complaint, quote, alleges that defendants were aware at the time of the SPO of present facts that made the statement in the SPO misleading. That's the record at 8. The court did not cite any paragraph or page in the amended complaint in connection with that statement. And indeed, that's because the facts don't appear in the complaint.
Was there no allegation in the complaint about the fact that they're alleging that 2 major customers were lost at the time the statements were made, and that was not disclosed, which made the statements misleading? Is that not alleged in the complaint?
So there were two principal allegations in the complaint. One related to a decline in business in the Chinese market. And so what
I'm just mentioning the other one first, so why
Yep.
don't you address that one, which is the one I'm asking about.
Of course, no
Isn't
problem.
that not alleged in the complaint, that that was something that should have been disclosed in order to make the statements not misleading?
The plaintiff does allege that there was allegedly 2 lost customers, and it should have been disclosed. However, they do not allege when those customers were lost.
Don't they allege that the customers were lost before the statement was made, which is what they're alleging made the statement misleading? If that's so, why isn't that enough to survive a motion to dismiss as to that particular misrepresentation?
Yeah, with respect to that element of the complaint, there's really 2 reasons. One is that they don't allege the impact of that loss of customers, whether it was material. That is a required element of a 33 Securities Act claim.
Since you specifically made the representation that you had this loyal, select customer base, doesn't that by itself enough to suggest that losing 2 of those loyal, distinct customer base would have a material impact on the business, as a result of which it should have been disclosed, at least for purposes of a motion to dismiss?
Respectfully, Your Honor, that is not the way that we see the case law. The defendants are not aware of any case that has found that such a general statement about a customer base would be sufficient to be an omission that with respect to the loss of 2 customers, the size of which is not even specified in the
Well,
complaint.
how much is that loss of the business, those two customers?
The plaintiff doesn't allege the impact of that at all. Those 2 customers actually came from one of the smaller business units at the company. Plaintiff doesn't specify what the impact of that was. It doesn't specify when it happened, doesn't specify when the allegedly corrective disclosure was made with respect to that statement.
So you're saying there needed to be more allegations to make that sufficient?
Correct, correct.
So, but I mean, this is a pre-answer motion to dismiss, and we're not talking about a 3016 fraud standard. And the plaintiff says, you make an allegation in your prospectus in that you're going, because of your stable customer base, you're going to really be able to go in and get that emerging market. And the fact is that while you're saying that, you're losing 2 customers. 2, and they obviously can't say with specificity specific numbers, but the allegation is that was a significant amount of your business. If you don't think it's true, right, we go through discovery, and on a motion for summary judgment, you show that was only 3% of my market that did not make the statement in the prospective true. We are talking about a pre-answer motion to dismiss, right?
Correct. Now, there's two points there. I think with respect to that specific allegation, again, I would just direct the court's attention that they don't allege when the impact of the alleged decline occurred. They say sometime before March 2018, there was a loss of 2 customers. The SBO occurred in September 2018. The alleged stock drop on which they base their purported damages occurred in November 2018.
I mean, that is not like 6 years later. That is clearly in the case law in the Southern District and in this court. That's clearly not so attenuated that couldn't be at least pled.
And second, I think you cited 3016, and you said that this was not a heightened pleading standard. Respectfully,
We're all agreeing it's not a heightened pleading standard.
Right.
Before we run out of time, now let's address the other, we ran out, but quickly address the other misrepresentation or omission they're claiming, which is that there was a sharp decline at the time of the offering in the business in China. And why isn't that sufficient?
with respect to the alleged drop in China, I'll point to a couple things. First, there were robust risk disclosures that described, and I can quote from them, they described and I'll quote, "We operate and sell products to customers outside the U.S. and are subject to several risks related to doing business internationally. We face risks including changes in monetary and fiscal policy."
Very general statements. Why isn't it enough to state that there was a very specific thing already occurring? And if you're going to make those general statements, that you should have made the disclosure about the risk that had already occurred before the time of the offering that resulted in a sharp decline in business. Isn't that misleading or allegedly misleading?
And that goes back to the first point I made with respect to the allegation that the lower court relied on that isn't in the amended complaint. The lower court found that the reason why the statements were misleading is because, in the lower court's view, the risk had already materialized and that was known at the company at the time of the offering. That is not alleged. That specific fact is not alleged in the complaint. It only appears in the plaintiff's opposition to the complaint. And so it's for that reason that we would respectfully request this court to reverse the lower court and dismiss the complaint in its entirety.
Thank you.
Good afternoon, Your Honors. Deborah Clark, may it please the Court, Deborah Clark Weintraub from Scott & Scott for the plaintiff.
Can you specifically address the arguments made by opposing counsel that there was not enough specificity in the complaint about these omissions?
Yes, absolutely, Your Honor. Let me start with the allegations relating to Power Solutions. Those allegations can be found in paragraph 55 of the amended complaint, and they're based upon statements made by a confidential witness who worked in that particular business, part of the NN's business in the Power Solutions segment. And that confidential witness reported that the loss of these two customers had a adverse effect on Power Solutions sales and performance in 2018. And the confidential witness reported that the customers had been lost by March of 2018, so in an earlier part of the year. The truth with respect to what was going on in the Power Solutions business was revealed in November 2018 when the company announced its very poor performance for the third quarter of 2018. So all of the facts that opposing counsel indicates were not alleged in the complaint are there, and the trial court's determination that we had pled sufficient facts to allege material untrue statements and omissions with respect to the statements made about the Power Solutions part of the business, the stable customer base, et cetera, are properly pled and adequately pled in the complaint. With respect to the Mobile Solutions part of the business, I think you have to step back when you're thinking about the case, as the trial court did, and realize the context in which these statements were all made. NN, at this point in time, at the beginning of 2018, had just completed this purported transformation of its business. It had purportedly transformed itself from just a steel ball and roller operation focused on the automotive market into what it claimed to be a diversified global business that had different sources of business and revenue and profits that would make its business not only more profitable and higher growth, but also less cyclical, more predictable. And what it talked about Mobile Solutions, it talked about in particular the emerging markets in Asia, and that those were had high growth markets, and that the company had expanded its plant in Wuxi, China, in order to accommodate the new business that it was expecting.
So, counsel, what is your response to the risk warning that says we depend heavily on a relatively limited number of customers, and the loss of any major customer would have in the future a material adverse effect on our business? Are you saying that that had already happened and that wasn't disclosed?
Exactly, Your Honor. That's exactly right. And as to both aspects of the business, the risk warning they rely on with respect to the Mobile Solutions part of the business, that had also come to pass.
What's the response, before I forget, what's the response to the argument made by opposing counsel that you don't really quantify in any way how much the loss of these two customers really mattered to the business one way or another?
We don't have to give a specific quantification of that, Your Honor. Again, this is a pre-discovery motion to dismiss. That's not required as part of the pleading standard. I think we have alleged sufficient facts in the complaint to indicate that this had a material impact on the business.
It would only be material if they were important customers, correct? I mean, if they were inconsequential customers and you lost two customers, it wouldn't be material.
That's correct. And as I said, the confidential witness that we cite in the complaint reported that the loss of these customers had a consequential effect on the business.
And was the third quarter loss significant?
In the third quarter, the company missed its external guidance and reduced its guidance for the remainder of the year. In terms of the China market, the defendant, Mr. Holder, talked about during the conference call the fact that it was these changes in regulations in China that resulted in the decline in that market, and that had an impact on the business in the third quarter. And we allege a multitude of facts in the complaint showing that this decline, not only in sales of automobiles in China, but also production, right? Because NN is dealing with the people who are supplying the parts for the automobiles. Both of those things were declining since the beginning of the year. I mean, those are facts that the trial court relied on in finding that we had adequately alleged our claims in this case. So, Your Honors, I would respectfully submit that the trial court's order should be affirmed in all respect. But let me just say, one important point for the plaintiff respondent here is if the court intends in any way to reverse the order of the Supreme Court we should be remanded in order to allow the court to deal
Well,
with our
did you
motion.
ask that for that relief in the lower court?
I'm sorry, Your Honor.
Did you ask for that relief in the lower court?
Yes, we did, Your Honor. We asked for leave to amend in the event the court was going to dismiss any aspect of the case, which it did not, obviously. Thank you, Your Honors.
And may it please the court. With respect to the two allegedly lost customers, I just return the court's attention that the plaintiff does not allege any negative impact on the Power Solutions business from the alleged loss of these customers. In fact, it's publicly available information that the Power Solutions business grew in the first and second quarters of 2018, including with its largest customers. Again, plaintiff does not allege the impact of the loss of those customers, does not allege when it happened, sometime indeterminate after March 2018.
Well, how do you deal with the third quarter results? How do you deal with the third quarter results?
So again, the plaintiff has not alleged that those third quarter results were resulting from the loss of those two customers. Those customers have been lost, according to the plaintiff's allegations, prior to March 2018.
Right, and what they're saying was, if you had told us that, we wouldn't have bought your shares, and our shares wouldn't have lost their value because of your third quarter. I mean, it's not that complicated, right?
No, I understand, Your Honor, but the fact is they never allege when the truth became known about the loss of those customers. So,
I mean, do you think that that has to be, they allege a pretty close period of time in the same 3 quarters of things happening, and you're saying that they have to say on December 31st at 3 o'clock in the afternoon, that's when it happened? How could they possibly do that on a pre-answer motion to dismiss? I mean, in a pleading that is a general pleading of section, a 1933 case.
yeah, Your Honor, respectfully, there's just a disconnect again in the timing because they allege pre-March 2018 loss of 2 customers. Public information is the business, including those alleged customers, grew in the next 2 quarters. There was in the third quarter, announced in the earnings, a decline. However, there's no connection to the supposed loss of those customers or even the significance of those customers to the overall business. And for those reasons and others in our papers, respectfully request that you reverse the lower court. Thank you.
Thank you very much. Bernardez versus 70 Franklin Place. Yes.
Good afternoon, Your Honors. Daniel A. Thomas for the appellant, Kevin Bernardez. If I may, this motion for summary judgment, I believe that the court made an error down below because it failed to recognize that unlike other cases where facts say, was it reasonable, their conduct, did they do enough, there is no dispute of any nature that no investigation, no inspection, no evaluation, and no assessment was ever made of the electrical room floor. And the reason why it should have been done was because there were visual cues that would have keyed any construction professional, any building owner, into the fact that they need to confirm that this lolly column, these supports, metal and wood braces, which were visibly in place in open view, which they claim they did not put there, they were there before, so you have a long period of time.
So what evidence was there that the hand demolition of the walls in any way led to or caused the floor to give way?
Well, you have a scenario here, Judge, where there was only one electrical room. There's only one entrance in and out, and the floor had to be broken to go through to the sub-basement. So my client had testified, and he just wasn't asked the questions at his deposition, which is why an affidavit was required. He had to go through the floor, and they demolished the floor to go into the sub-basement where they were wiring there. So you have a scenario here where they're putting troughs in, which are runners for the electricals, along the walls. So there's doing demolition and installation. of these electrical troughs, and that's when this actually occurred. So you have no inspections at any time, and the industrial code that I requested be added, and as this court has done in the past with
I'm sorry, I didn't hear the answer to the question that was asked, which what's the connection between the electrical work being done and the demolition being work on the electrical work and the floor falling or collapsing?
Well-
Why was one the proximate cause of the other?
to the extent that he was going through the floor to run wires, there is your breakage of the floor in through the
But
walls.
he says he just stepped and the floor broke.
That's right, and he stepped in the floor, and there were lolly columns underneath where he had
But what does
fallen.
that have to do with his working on the walls?
He wasn't working on the walls, they were affixing the troughs to the wall, Judge. So they were putting wires through the wall, down to the floor below, and they were affixing these troughs, these electrical troughs. That's
So
what
again, what is the correlation between his working on the walls, doing work to the wall, and causing his falling through the floor?
you have a hammering, you have drills, you're affixing these things to the wall, but ultimately that's only as to the 241-6 claim, Your Honor. There's an entire component of this case that deals with the lack of inspections, which again is part of the industrial code, that there was no inspections at all. So the only connection is the troughs that were being affixed to the wall. And he was standing on the floor when he was cutting the troughs with his.
So where in the industrial code would it be required that there be an inspection of the floor for work that's being done to the walls?
Because that code covers walls and floors, Judge. 3.3C covers walls and floors, and the need for continuous inspections if there's demolition work to any of them.
But they weren't demolishing the floors.
They were not. They were doing demolition to portions of the floor to go through with wiring. So it wasn't the entire floor. There were sections of floor that were being
Claim
demolished.
that he was affirmatively doing some work on the floor and that's when he fell through? That he was demolishing part of the floor and he therefore, is there any allegation of that sort?
Not at the instant which he fell through, but they were in the process of cutting these troughs for the sake of affixing them, replacing the old ones, putting in new ones.
Wait, are you saying like the day before somebody was working on the floor and that's what caused it? I don't understand. When are you saying the floor work was done?
The floor work was done over the course of their work that they were doing, but on the day he fell.
Where is that in the record? Where in the record does it say we did something to the floor that destabilized it?
You can find it and tell us on rebuttal. Thank you.
Thank you, Judge.
May it please the court, Michael Kazores for the respondent, 70 Franklin Place. To answer the most immediate question, there was no demolition or any type of work being done on the floor at any time prior to the plaintiff's accident. Counsel also mentioned that there was no inspections whatsoever. That's not accurate. The general contractor testified that a pre-work safety inspection was performed and that the structure was sound. As to the decision by the lower court, it should be affirmed in its entirety. There's clearly issues of fact as to whether the defendants had constructive notice on.
But there was no structural integrity inspection done of the area in which the plaintiff was working. Is that correct?
Well, he testified that there was a pre-safety inspection of the building and that the structure was sound.
The ground floor, right?
It's unclear as to, what
That was the
portion.
ground floor, right?
The incident occurred in the basement. And
Right,
it was
and so the structural integrity inspection was of the ground floor, not the area where the plaintiff was working.
Well, he testified that there was a pre-safety inspection. I think it's unclear as to the actual portions of the building that were inspected, but Your Honors, under the industrial code that the plaintiff is relying on, and I think Your Honors touched on it earlier, it's clearly inapplicable because there was no hand demolition ongoing at the time of the plaintiff's accident, nor was there any hand demolition that had taken place in the building that could have possibly compromised the structural integrity of this floor. And for that reason, the court was correct in dismissing the 241 sub 6 claim. Regarding the common law negligence in the 200, there's clearly issues of fact as to constructive notice, particularly where the plaintiff and all the defendants testified that they were walking all over this floor for weeks and months before the accident. No one had any safety concerns whatsoever. no one anticipated that this incident was going to happen. With regard to the 240 sub 1 claim, it's clearly inapplicable. The court was correct to deny plaintiff's motion for summary judgment. The plaintiff has not demonstrated that there was a foreseeable risk of an elevation-related danger present here, nor that there was an enumerated safety device that he should have been provided that would have prevented his fall. So if your honors have no further questions, I'll rest on the brief. Thank you.
Thank you.
Good afternoon, Your Honors. Michael Lenoff from Carter, Falser, Turpin, and Lenoff for LF Franklin LLC and Centaur. Our brief is identical to the other respondents, so unless you have any specific questions for me, I'll rest on the briefs.
Thank you.
Okay.
If I may, Your Honors, the affidavit of my client at 1698 of the record, then the supplemental affidavit, but I would like to also address the fact that the absence of any inspection whatsoever means that there is no scenario where the motion court said that a jury could reasonably find that none of the defendants are responsible. This is not a situation of did you do enough of a job. They did nothing, and there's no indication. This pre-work inspection, irrelevant. It didn't happen in connection with this room. The very person that said that, Mr. Katzman, at 713 and 742 of the record, admitted in his deposition he did not do an inspection. He's not aware of any inspection, and that, to his knowledge, nobody was hired, and the current owner, 70 Franklin Place, did a walkthrough and expressly said never did an inspection, didn't hire any engineers. So they have these clear indications, and the one thing you've got to be mindful of is that these columns are indications of foreseeable risk of collapse. The only reason you use it is because there is a foreseeable risk of collapse. So under 200 and 240, Your Honors, I think it's very clear that the lack of inspection makes those cases. In terms of the 241 claim, it's the plaintiff's affidavit, both his first and his supplemental, that deal with the floor in terms of that. So unless there's any further questions?
Yeah, thank you very much.
Thank you.